Hi everyone. So today I'm going to talk about a very interesting bucket that I intend to introduce you all to. It's basically I have discussed in my videos and through these entire video outlines that I have shared. So basically I have talked about the economy where I've been projecting the future till 2070. Then I talked about a finance topic called securitization. I gave a bit of an overview. I'll discuss any other finance topic if something gathers in my mind, and I'll let you know. And then I looked about the geopolitical trends of the Taiwanese conflict vis-a-vis China. Today, I want to talk about one of the favorite things, rather the subject with which I have graduated in my bachelor's from National Law University, Jodhpur, and the subject of law. And within it, one of the key subjects that I love about within this entire discipline of law is jurisprudence. Now, I had a good jurisprudence professor that has explained to me the nitty-gritties of jurisprudence as much as required to be done, and to help whatever knowledge I build on it to educate you all about it. So today I'm going to give a brief introduction, not a brief introduction. I think that this video might also be elongated, but let's see. I'll give a brief outline as to what the topic that I'm going to deal with. So it's basically an introductory topic because I want to apprise you all with this subject because it's not very difficult to understand it, but once you get a hold of it, you might be intrigued about it and you might be curious to know what it means and what deeply it might contain. So this I'm going to talk about is this particular video is about what is law, what is the law, and what is law. So this is a very interesting thing to understand because most university courses conceive the course of jurisprudence to include an examination of legal theories and select legal concepts and make an attempt to place them in context of a legal system. They place it with, they evaluate it, they critique it, and they put it in the nature of whatever the things of laws and the legal system is, and they question it with strands of different branches of trees such as justice, morality, power, the conceptions and techniques they use to come about this interrelationship. So, unlike most black letter courses, this one requires you to think jurisprudence as a subject because this course is rather you have to read a very copious assortment of often turgid and often impenetrable ideas from leading scholars, and basically they make frequent presumptions on different grounds of sociology, philosophy, anthropology, even economics, and even there is a greater apprehension that is compounded by the fact that some of your peers actually give an understanding of it. So I have faced it with the perilous depths of going into this subject. It literally blows my mind, but as I go deep into it, I understand that how shallow my knowledge is. So what I'm going to talk about is that we know that jurisprudence and law itself, as the topic which I'm dealing with, is haunted by a question of definition. Now, Professor H.L.A. Hart, he is one of the leading contemporary analytical philosophers. He has died. He was rather, I would say, of 20th century of the modern era. So, in his definition and theory of jurisprudence that he has discussed in the essays in the jurisprudence and philosophy, particularly that book, which if you have read, I'll highly advise you to read because that's the first book with which he introduces his topics to the world. The fact that Hart also devoted his inaugural lecture after being elected to the chair of jurisprudence at Oxford in 1953 to this question, which gives us an indication to the importance which is attached to the matter. The definition. In the essay, of definition and theory of jurisprudence, Hart warns against the danger of theory on the back of definition. What he means is that it might serve as an ideological function as well, because there might be different ideologies with which you might understand jurisprudence and you might denote it with. So, in short, there are three ways to approach this problem of definition that I've researched and analyzed. So, first is the denotism. So, to mean is to denote. So, basically, if you correspond to an appropriate denotatum, so in a way, if you say Fido, basically, if you have a dog who is Fido, so that dog will answer to that call, means you're denoting that name to that essential thing, that being. So significance is here is given to the proper names of it. Even for instance, you attach fictitious names to proper nouns. So that is one such way of denotism. A second approach that has emerged and rejects this denotationist view is by a Cambridge philosopher named Ludwig Wittgenstein. He said, don't ask for the meaning, ask for its purpose, its use. The use is its function, which is employed to do. He gives an example of chess. Now in chess, a knight is basically has the meaning once we know the rules of chess. Unless we know those rules, it is merely a piece of wood for us, because we won't know what the essential characteristic property of a knight is in a chessboard until and unless we know the rules of the chessboard. So the chief attraction of this approach is that it enables us to fix a meaning to certain legal concepts without the need to employ fictions to correspond with the meaning attached to the certain concepts. A third position is known as essentialism. It basically argues that things have essences to identify them as particular things as they are. So I'll give an example of two other philosophers whom I'll discuss about, John Austin and Hans Kelsen. So they are also leading jurists and leading legal philosophers of the Austinian, of the Hart era, or modern philosophers they are. So they sought to define law in reference to its fundamental nature. Austin defined it in terms of commands of the sovereign, and Kelsen defined it in terms of a normative system of grundnorm with a entire pyramidal structure. So ideological and political preferences might intrude in this inevitably based on the social, historical and moral considerations, provided we are alive to these issues and we are not shying away from elucidating the idea that infuses the legal system. Instead, unless we do so, conceptual confusions might actually inhibit us. So I want to deviate a bit and I want to introduce you to an interesting branch, substratum of law, which is the descriptive theory of law and the normative theory of law. So descriptive theory of law is that it explains what a law is, why the law is, and what are its consequences. You could say that in the first instance, what law is basically a doctrinal question. It basically analyzes the cases that elucidates some underlying theory. It is doctrinal in the sense that it applies a particular doctrine to see that whether this law particularly fits into that doctrine or not. Secondly, descriptive legal theory may be explanatory. As you may know, Marxist legal theory is explanatory in the sense that it offers an account of law as expressing the interests of the ruling class and the subordinate class. So an expressivist theory from an explanatory standpoint is also a descriptive legal theory. The third aspect of descriptive legal theory concerns the consequences that might follow. For example, economic analysts of law might use the tool of analysis to predict probable behavioral effects of a strict liability regime, let's say. So on particularly, like let's say on manufacturers. Now a particular doctrine might apply of strict liability where if anything which is poisonous or hazardous, if it escapes, then the manufacturer will be strictly liable. So they might analyze the potential economic costs to that. So it can be analyzed from a consequentialist point of view as well. Normative legal theory, on the other hand, is concerned with values. Such a theory, for instance, seeks to establish whether strict liability, such as that what I have explained, ought to be adopted in order to protect consumers or not. Normative legal theory is basically pursues a very idealistic aspect of law, or a non-idealistic aspect as well, but the former is much more relatable because legal rules would create a best system that it would politically achieve. On the other hand, if it is non-idealistic, then it presupposes any such constrictions on the choice of legal rules, such as difficulty in enforcing such rules. They would first pre-ascertain these constraints and then decide whether or not the legal rules fit into the legal system or not. So there is no clear-cut distinction between these two theories. To give you an example, it is basically from a utilitarian theory standpoint, it is hard to sustain the normative theory of utilitarianism without a descriptive content of the consequences of the application of a specific rule. For example, whether rule X causes the greatest happiness, which is result Y, without a description of these consequences would be a sort of, it would be difficult for us to ascertain the result vis-a-vis the cause of itself, the cause with which you are doing that action to gain that maximum benefit or the highest happiness out of it. Similarly, descriptive legal theory may, on the basis of predictions about the likelihood of success of, say, law reform, put a brake on normative legal theory's improvement as well. Now, critical legal theory basically questions, there is a particular branch, another branch as well, which is called critical legal theory, which questions the very foundation of jurisprudence. It is very anarchist in the sense that it is a very woke kind of a thing, that it questions the very basic fundamentals of a jurisprudential point of view from a framework of, let's say, from a feministic standpoint, or from a heterogeneous, homogeneous caste or any such racial critical theories standpoint. So it questions the basic foundations of jurisprudence. So that's critical legal theory. But normative jurisprudence, so in short, deals with the moral foundations of the law. And there is another substratum which is different from normative jurisprudence, which includes within descriptive jurisprudence, which is analytical jurisprudence, which examines mostly the metaphysical foundations of law. What is it based on? What is its grounding? So, you will perceive how normative and descriptive theory may be grafted together to yield a sort of a hybrid legal theory as well, which is in I'll explain another legal philosopher that I'm introducing, whose name is Ronald Dworkin. He has had a theory of law as integrity. For example, there might be an amalgamation of the goals of the descriptive doctrinal theory of law and a normative theory of law. By claiming that a theory of law should both fit and justify the legal materials, his theory explains the descriptive doctrinal legal materialistic point of view, which coalesces with the normative legal point of view, that as to whether or not these legal rules, these particular theory of law best fits or justifies in terms of the political and societal and moral considerations or not. So his theory is basically an amalgamation of both descriptive as well as a moralistic standpoint. However, I'll argue also in further videos that his theory still falls short, because it's mostly an interpretivist, moralistic theory that he prescribes, which falls short of the descriptive analysis of how Andre Mormor, and there are many other philosophers of the positivist camp who basically object to his way of including the things into a sort of an assortment which probably positivists don't talk about, which they do in fact. So I'll talk about that later. Now let's come to this meaning called law, which I talked about in terms of quotations. That is the semantic theory. Semantic theory of law means that it basically talks about its meaning. So it's a very linguistic analysis if you might look at from that perspective, because it might then say that law functions what the linguistic term as a mass term such as snow or meat. However, we know for sure that you can't play with a snow. Similarly, but contradistinguishingly, you can create, apply, study, detest, or obey a law. So, in this sense, if law is like a rock or a particular lamp, by themselves they are masters, but when they are preceded by an indefinite article, which is an or a the or pluralized, they convert into a counters. And so, just as when we ask how many rocks are in the garden, we are basically saying that we are asking for particularly how many laws which govern a particular substratum of subject. Let's say telecommunications. What governs telecommunications? How many laws are there? How many regulations are there? So we are concerned about that from a countable perspective, from a pluralistic perspective. There we are adding the numbers to the mass terms, and then we are contemplating from a very linguistic perspective. But law is simply not that. That is my entire point. Now, another important thing is that we can consider the law, or from in the quotation law, in terms of a particular social organization. Let's say that law can receive a definitive article, we can talk about the law, while to add an indefinite article or a pluralize it might change its meaning. The same particularly when you talk about, so basically from an organizational point of view, you can have institutions, you can have mechanisms such as judges, senates, cabinet secretaries, judges, who basically apply the law. Whereas they, on the other hand, there are legal systems, which basically, again, legal system in itself is also an ambiguous term like law is. It can be considered as a sum total of laws with which a particular country or a democracy operates. So what I'm trying to mean is that from a institutionalized perspective, law can be considered as a people oriented kind of a subject, or if law is a sum total of laws which constitute a particular legal system of a country or a democracy, then it can be accountable in terms of a legal normative, legal norm standpoint. So here you're understanding the friction between an organizational perspective and a normative norm perspective, legal norm perspective. These two systems are also there. Whereas this organizational perspective which I'm talking about, that talks more in terms of the anthropological, historical, sociological theories of law that I will come to later. Whereas the legal norms perspective, which talks about the sum total from its mass terms, it is basically talking about a normative and a descriptive or an analytical jurisprudence standpoint. So my point here is simply to highlight the ambiguous nature of the terms law and legal system is, in a preliminary way to resolve the ambiguities, we need to identify core questions in jurisprudence. As we can't be like fussy about whether legal norms and legal organizations both instantiate the same property, because they are both legal things. We may presume it that legal organizations, because they are doing it on the basis of legal norms, or legal institutions which exist independently, they are making the legal norms. I'll talk about this friction as well. This is basically the chicken egg puzzle. So from a legalistic standpoint, both of them might be on the same pedestal, but I would simply say that I will be referring to the property that can be instantiated by rules, organizations, officials, states, texts, concepts, statements, judgments, and many things. So idealistically, we shouldn't look law from a perspective of an organizational, historical, sociological, anthropological standpoint. Neither should we look at law from a basically its legal norms standpoint, because both of them are dependable upon each other. But let's say I can make assumptions that one can survive also without another. For example, if I may give a simple example of how I'll talk a brief about the chicken egg puzzle. So, what came first, a chicken or an egg? So, this is a question which has perplexed the minds of many people from a human standpoint. So, what basically should be the cause of one property should be basically dependent on that same property. So what I'm trying to mean is, if basically the egg has come first, so we can assume that there must have been something presupposing the egg, which is a chicken that has laid birth to the egg. But that doesn't explain the standpoint of how chicken has come, because then to predate that we have to assume that there has been an egg which has led to the birth of the chicken. So basically there is a contradiction between the two, because when you assume one property from its standpoint, from its beginning, from a Humean standpoint, that A causes B, therefore A should predate B, you have to explain that either A is identical, either A is independent of B, or A depends on B. This is my point, which is a very perplex question to deal with, and I'll come about that later. But I hope you got the gist of it. Now, basically, it is so. Now, one obvious reason why I think legal philosophy should not be solely concerned with the definition of law is that law is an English word and English speakers associate with it. Furthermore, it is not even possible for an English speaker to do legal philosophy simply by considering the proper use of the word law, for it can be under-inclusive as well. For example, I'll give an example. Let's say we consider a particular chemistry law or a law of mathematics, like law of cosines, or a chemistry law like Boyle's law, or basically the law of gravity from a physics standpoint. So it can be basically under inclusive because its proper usage of the word law may not be associated with the terms with which we just now use, because its properties can be different. The subjects can differ here, because we are talking about physics, we are talking about chemistry, we are talking about maths, we're not talking about law. So there it can be under inclusive, or it can be over inclusive as well, because it might not look at law from a very relevant sense. Because as basically there is a point which I wanted to make, is that English speaking lawyers normally reserve law as this word for rules that have been enacted by legislatures. However, we know that a Congress can pass a law. We know that an administrative agency can pass a regulation, like someone under let's say Ministry of Finance, the Department of Ministry of Corporate Affairs. It can pass a regulation, it can pass a rule, it can pass a law. So these are all functions which can you may assume that they are not law because they are not talked about in the proper name perspective as law, but they are still law because because if you look at it from a linguistic usage, you will be fooled by it. You will say that regulation is not law. Then how can you explain that whatever is something which is done to basically prescribe something, a conduct, or give value to something, is dependent upon a particular organization or a body that makes it? So you might be fooling yourself from a linguistic standpoint. So you understand the law can be under-inclusive as well as over-inclusive. Over-inclusive in the sense that it may not be relevant, it might maybe dealing with the other branches of law where its relevance is not there, or it can be under-inclusive because if you're looking at it from strictly from a linguistic standpoint, you are missing out on a regulation or a rule which might be also considered as law, which might be also passed by the legislature. However, we know that executives can also pass law. However, we know judiciary can also pass law. we have to respect that these systems exist with each other. They can't be held under inclusive or over inclusive simply by their linguistic expressions. That is my point. Now, I want to talk about a particular point which there is a legal philosopher who is also suffering from a very grave disease, and I have condolences for that, and I wish that he's well. He's, however, active on LinkedIn. His name is Leslie Green. He has a motor neuron disease, which I am pretty much sad about, and I feel that I hope that he's better, and whatever he's doing, God gives him strength for that. He says that law's nature resides principally in understanding the way in which an instrument operates. There can be two ways of looking at law now. So what did I talk about? I talked about law can be simply from the perspective of a proper noun perspective, where if you talk law from a linguistic sense, then you might be simply attributing it to a particular thing. Then there was a functional usage where I talked about from a Wittgensteinian point of view, where law can be used as a particular function or a goal or a purpose with which it serves. Then third was an essentialist point of view, that from a perspective of law vis-a-vis what I talked about, Austinian law being a command of the sovereign, that is the essence of what Austinian law is. Or from a Kelsenian perspective, it can be a normative system of pyramids of norms. I'll come to all of these later, you don't need to worry about it. But you need to understand what I'm trying to say is that, so these are the perspective with which you can consider what law is from a semantic standpoint, or you can consider what the law is generally from the standpoint of its mass usage terms. However, we have also understood how law can also have an indefinite article or a plural term to basically use it as a countable noun. Basically, if you add an or a the, or if you extend it to pluralistic, then it can become plural. We have understood that. We have understood the fact that law can be also, in terms of its descriptive and normative theory, it can be it should not be ideally under inclusive or over inclusive. Then it would miss out on a particular functioning of an organizational standpoint, which basically the whole point of the chicken egg puzzle that I will talk about later is dependent upon, because laws as a separate identity, if you even consider it from legal organizations, they have to mutually depend on each other. They can't independently, they can independently exist. That can be an argument, but they also depend on each other. That is the Humean standpoint of a cause and effect relationship. So we understood that part, for which we understood that it shouldn't be over inclusive or under inclusive, in the sense that in over inclusive it shouldn't basically state that it includes other branches where law is irrelevant, particularly in the branches of chemistry, in the branches of physics, in the branch of maths, or under inclusive that it is missing out on the perspective of the organizations such as the executive, judiciary, or the legislature making the law. Now we come to the part where Leslie Green has talked about. He uses basically an analogy which I will discuss, with which I will introduce you to a topic called modular understanding of law and functional understanding of law. Now, an analogy to illustrate the contrast between modular understanding of law and functional understanding of law is, consider what a Swiss Army knife is. You have seen a Swiss Army knife? So it is less reference to the specific purpose that it may be used for. It can be used for multiple purposes. In that sense, it is a modular form, because it has various purposes to which it can attach itself, bundled together into one implementation. That is the knife. So that reference of knife can be used for cutting fruit, it can be used for cutting vegetables, it can be used for stabbing someone, it can be used for anything. By contrast, we understand what basically, let's say, a saw is. What is an essential property of a saw or a hammer? It is to basically strike a nail, or a saw is used for sawing or cutting down trees. So that's what basically the essential property is. So it has a very singularistic function of that particular object. So that which serves as the specific function is the functionalist perspective of law. So we can classify theories of law into a modular kind and functional kind, as I have said. In this video and in my subsequent videos, I will talk about the functional kind of law, which associates with Lon Fuller. Then there is Nigel Simmons. Then there is Dworkin. But I will talk about model theories of law, modular theories of law, particularly in this topic, because I consider myself to be a legal positivist. So I would love to discuss legal positivism with you so that you can understand it more. Because when my teacher or my professor in my college had introduced me to legal positivism, I was like, what the hell is this? Because positivism is something which is a very scientific term. So are we going to learn legal science in this? Is something like you are using different chemicals to come to a particular reaction and a solution to it, or you are using particular mathematical formulas to derive a particular gravitational or some Newtonian physics standpoint. So it's not that. It's very like the whole idea is that you have to associate some things to be detached when you are coming out and studying this subject. There are many predated presumptions that you might have in your mind while exploring this subject. I would strongly advise you to not have those predated assumptions at all. So the most influential about modular theories of law, coming back to it, the most influential theory of modern day philosophy is that of H.L.A. Hart. I'll talk about H.L.A. Hart's theory in detail, but I will introduce him to you all. So he has developed a concept called concept of law. Though I intend to make a video on all these philosophers that I have been discussing about, but you have to understand that I am also employed in a particular bank. So if suppose I am right now free, so if my work doesn't come late, or basically if my work is so much that I am not able to make a video out of it because it requires heavy reading and I haven't made notes out of it. So I'm just saying from a perspective of what I have researched simply and what I know about from already reading and tackling with this subject beforehand. So please, I want to apologize. Don't curse me that you are missing out on the subjects, because I'm free right now, so that's why I'm dealing with these subjects. Now coming back, so basically I can give you a brief idea about what Hart's idea is. So the very general aspect about a modular conception of law according to H.L.A. Hart is about guiding and criticizing conduct. Now the function does not distinguish itself from an etiquette or a religion, because there also religion is prescribing you to follow certain duties and you have to detest from doing something that is considered sin. Then there are things that if you do it, you will be considered holy or pious about it or divine about it. So there are ways in which you can look at it. Now in Hart's view, law is distinctively primarily in virtue of the ways in which it serves as a guide to conduct. The central idea of Hart's theory describes a law guides conduct as a system of rules. Now, rules which require a person to do or not to do something, that is called primary rule. And laws about how the rules of the system comes into existence is called secondary rule, which you can basically adjudicate upon. So primary rules are something which are basically what you should do and what you shouldn't do. It's about what, when you are inside the game, what you should do in that game or what you shouldn't do in that game. And secondary rules is it takes you back from a neutralistic standpoint, from a referee. You're adjudicating whether or not those primary rules within which the player is playing, whether or not that is more justifiable or not legally. Second is that a rule belongs to the system, hence it's a legal rule, if and only if it is recognized as a rule of the system by a master rule, which is the rule of recognition. So law predates to a particular rule, and that rule ultimately counts to the master rule, which basically is the rule of recognition that gives the validity to all the rules that are existing in the legal system, which is the crux of the positivist camp, and most particularly popularized by H.L.A. Hart. And third aspect is that the rule of recognition exists because the practice of the officials accepts that rule. Now, I'll give an example from the perspective of football because I like football and I'm a big Manchester City supporter. So, in England, the Football Association determines what rules are. The FA recognizes the FIFA laws of the game govern professional football matches in England. Now, the rules may include that outfield players must not handle the ball during the course of play. They can't use hands to move around within the field within the field within the premises of the field, and then there must be a referee who has the power to determine whether the rules of the game has been infringed by the players or not. So here what I am trying to say is that rule A requires participants in the game to refrain from certain actions in terms of not using hands to play with this football game. That is why we say it's a football and not a handball. In Hart's terms, this is a primary rule of obligation. It requires human beings to do or refrain from doing certain actions. Contrastingly, rule B is basically distinctionally, rule B does not itself requires a referee to do anything. Rather, it confers a power on the referee to adjudicate upon the terms of whether the participants are violating the rules or not. So this game of professional football is a game of primary rules and a secondary rules. So the rule about the primary rule is secondary rule because the referee is not being told what to do by a primary rule. Rather, the referee is being conferred a power to determine whether the primary rule, which is played by the participants in the game, is infringed or not. A secondary rule is only from a neutral standpoint, from a referee standpoint, who has the power to determine whether or not the participants have violated the rule or not. You get it? So, what determines whether a rule is a rule of law? Now, this is interesting because I am using it from the terms of football. So, a rule is a rule of law is similarly a rule that recognizes certain rules as belonging to that system of rules. So, just because I say that in England the Queen of Parliament, what she enacts is the law, or the King of Parliament, what he enacts is the law. Similarly, when it associates to the system of rules that predates from its historical foundations, that it has been, as a tradition, it has been carried on, we come to an assumption that the practice of officials following such a tradition becomes a rule, and that rule becomes a rule of law. So, rule of law in itself is also a very different administrative law standpoint, which I would talk about in some other video if I can. There is Razian point of view as well, the affirmative and the negative aspects of rule of law. I'll talk about that later. But what makes rule of law, or particularly the law as a whole, as a legal positivist, is that the members of the group, the officials, have accepted the practice. That's the essence of what makes a positivist a legal positivist. That is why it's not a science. Similarly, the rules can contain bad rules or good rules. Everything depends on what the rule of recognition, what the officials of the system has accepted. If they have said that I accept what the parliament has enacted, which the president has signed to give an assent to, is a law, there is no logical guarantee whether the content of law requires to meet a moral standard or not, it will be counted as a law. That is the positivist argument. Now, there might be attitudes as well. Basically, you ought to follow something. Now, this basically from the perspective of Hart's view, from his book, The Concept of Law, the basic gist that I have gathered from reading it peripherally is that the officials, principally the judges of a legal system, must similarly regard the rule of recognition as a binding rule. They must think that they ought to follow the rule. Just because I say that I am playing a game of chess, now if I don't know that a bishop moves diagonally, I will simply consider that bishop to be a piece of wood for me, because that would be useless for me, because I know that the bishop moves diagonally, hence I'm playing this game. I have accepted the fact that the bishop moves diagonally. I have accepted the rule of the game. This rule has been determined on the basis of, let's say, a parliament of chess has created this rule and I am simply abiding by it, so I consider it to be binding upon me. This is what makes you ought to follow a rule for in posterity as well, because it has been a binding for you. It has been binding not only for me, for anyone who plays the game of chess. So why was Hart insistent that law requires the existence of a rule of recognition than simply a mere habit? The main reason is that mere habit among officials of recognizing that whatever parliament enacts as law would not explain in the sense in which parliament has legal authority to make law. It would not capture the sense that the officials ought to recognize the parliament to basically enact this law. They ought not recognize the parliament as the legal authority. In the game of chess, if I don't recognize the authority which has said that the bishop moves diagonally, then I am not only disrespecting the legal authority which has made this game of chess, I am disrespecting the game itself, because then I will be an outlier and an outcast. I would not be part of the legal system in which the game of chess is being played. This is what I simply want. Here also you need to understand one thing which Hart has said, that he insists that this ought is not simply a moral ought. Because the rule of game, just because it uses normative language that you ought to do something in the game of chess, that the bishop ought to be moved diagonally, here it's not the same meaning as, let's say, you ought to torture children for fun. Basically, from a moralistic standpoint, we are not making evaluations here. We are just simply saying that you are using ought not from a normative standpoint. Why? Because legal obligation is not the same as moral obligation. The fact that one is legally obligated to do something is ipso facto does not mean that one has the moral obligation to do something. Here is what Dawkins has basically deviated from Hart and said that legal obligation includes moral obligation, which I'll talk about that later. That's a different game altogether. That is the interpretivist game which Dawkins plays. But I argue that legal obligations and moral obligations can't be conflated with each other. Now, here is an interesting point which I want to talk about. I have talked about from a law and a game perspective to give you an understanding of what the essence is. However, you need to understand that there are certain limits to making this analogy with the games. What are the caveats? It is a contingent feature of games that there is a set of officials, whilst according to Hart, this is a necessary feature. Why? Because let's say a particular game like a hide and seek, you know perfectly well it's not simply like you need hide and seek officials to check whether or not you have hid somewhere. So you're getting the point. So there are games also which basically it has a contingent feature of officials being there rather than a necessary feature. So you need to respect that first. Second is that it is a contingent feature of games that there is a rule of recognition practiced by the players of games, or should they exist officials identifying which rules belong to which game, whilst this is a necessary feature of law according to Hart. So the participants of a hide and seek game don't have to adhere to a rule of recognition determining which rule belongs to that game. You getting me? So basically, participants of the hide and seek game are playing the game, but they are not basing that game upon an independent rule which identifies how to play that game. So they are not basing it or grounding it upon a particular rule. You can hide anywhere you like. The only point is that whether I catch you, that means you're out. I mean, if you have played this game, I have played in my childhood, so you understand the gist of it, right? So basically you don't need to determine whether or not you have to hide somewhere, whether there must be a set of rules which you have to adhere to, because the participants in itself don't have to determine which rules are applicable to them in this game of hide and seek. So that is why it makes it a contingent feature of law and not a necessary feature of law, which according to Hart is that there must be officials who must identify that such rules exist with the master rule to be considered as a necessary feature of law. You're understanding this distinction between positivism and the contingent feature. So I'll come to the third point. The rules of games have a narrow scope of application. They only apply to game related activities. Now, rule of cricket or rule of football would apply to a rule of cricket singularly, or rule of football will apply to rule of football singularly. But Hart says the laws govern many activities within the system. So there is a bouquet of lot of things which law does. So here you need to understand the rule of games only applies to the particular game and not to another game. So in summary, what did we see? We saw the law's nature understands its modes of operation. The law governs by different kind of rule, that those rules form a virtue of a master rule, the rule of recognition. The rule of recognition exists by virtue of the practices of the officials in the system, and that the law imposes obligations which are genuine obligations of a kind and which are not moral obligations, so that it governs all sorts of human activities. We understood this modular form. I will come to the point of functional theory of law in some other video. While I'll end this video here, I would come to a basic gist of functional theory of law before I start off with another video, because this video is already going above 45 minutes. So basic gist of functional theory of law is that law is an interpretive concept. The function of law is to insist that force must be used only to that extent that it justifies past political system decisions about when collective force is justified. Third is that law in a system consists the best moral justification of the past political decisions of the system, and law is a branch of morality. So these are in nutshell what the functional theory under Dworkinian system is, while there is Fullerian system as well, which I will talk about it later. I'll explain to you later. So this was in nutshell what I wanted to discuss about. Now I'll end this video here, and I will I'll make a short video right now about another topic which I want to discuss, which is also related to this, and then I'll come back to some other topic. Thank you.